Welcome to the Rational Egoist. I'm your host, Michael Liebowitz. I've always been fascinated with law and constitutions and the history of British law, American law. So I found an expert to come on and talk to us about these subjects. He's a professor of government and the Constitution in the School of Public Policy at UCL. I'm not exactly sure what UCL means. What does it mean, Professor?
It's certainly not UCLA. It's in London. It's University College London. It
Okay.
is actually one of the top universities in the UK and in the world.
Okay.
So I'm very proud to be a member of University College London and to tell you what UCL stands for.
Beautiful. Okay. Professor Robert Hazell, welcome to the show. Did I pronounce it correctly?
You did,
Oh,
Hazel. Yeah.
okay. Excellent. So, what exactly is the British Constitution?
Well, uh, unlike most other constitutions around the world, it's not recorded in a single codified document. And so some people say we have an unwritten constitution. That's not actually correct. It is written down. It's just that it's written down in several different places rather than being in a single codified document. And we're not alone in that respect. There are a few other countries around the world which also have an uncodified constitution. Examples would be New Zealand, Israel, and to some extent Sweden.
Now, one difference between the British Constitution and the American Constitution, if tell me if I'm wrong, is that the judiciary in Britain can't strike down acts of parliament as being unconstitutional, whereas in America, the Supreme Court can do that. Well, other courts can too, but the Supreme Court has the final say. In Britain, Parliament has supremacy, right?
That's correct. So courts can come close to it under the Human Rights Act, which was passed just 25 years ago in 1998, in that they can make what is called a declaration of incompatibility. So they can formally say and declare to Parliament, this part of our law is incompatible with the European Convention on Human Rights, go fix it. And Parliament then, in effect, is under a very strong political and moral obligation to remedy the breach. And almost invariably, Parliament has done so. That's as close as we get to a strike down power. But forgive me, Michael, that's not the biggest difference between the American Constitution
No,
and
that's just
ours.
a difference. I didn't think it was the biggest. Well, what
Yeah.
is the biggest?
The biggest by far is that we have a parliamentary system of government, like virtually every other country in Europe, and you have a presidential system. And that's a fundamental difference between political systems, because in the US, and indeed in most other countries in Latin America, which have copied the US, you have a head of the government who is directly elected, and you have a legislature which is also directly elected in the form of Congress. And there is no easy way when those two parts of the government each claim to have a democratic mandate, and they can rightly claim that, but they are in conflict, to resolve that conflict. Most political scientists, including American political scientists, agree that a parliamentary system of government is preferable because there is only a single source of democratic authority, and that is Parliament. And when the government is chosen from and accountable to Parliament, by definition, there cannot be a conflict between those two branches of government.
Okay, thank you. So, what were some of the major events in the development of the British Constitution? I suppose start with Magna Carta.
Yeah,
I know there was probably stuff before that with the Norman invasion, but I think Magna Carta is as good a place as any to begin.
let's start with Magna Carta, which now doesn't play much of a role, although there are fragments of it that are still in force. But what was big about Magna Carta was that it was the first time that it was formally declared that the king, who was then head of the government, as well as head of state, was formally subject to the law, just like everybody else, following a rebellion from the barons, who forced the king. He was very reluctant. He was a bad king, King John, so he was dragged reluctantly to Runnymede in 1215 to sign Magna Carta, and subsequently he repudiated it. So back in those days, Magna Carta had initially a rather short lifespan. It was resurrected a few years after, and has since been part of our law, but much more important, part of our way of thinking, a fundamental principle in the British Constitution. It was then the English Constitution, that the king is not above the law. And that was very unusual back in the Middle Ages, because almost all kings were absolute monarchs and not really subject to the rule of law. The other very big development a century later was the emergence of Parliament as an institution. And that also happened pretty early, during the course of the 14th century. And the House of Commons has been a brake on the policies and actions of the government at the time of the king ever since.
Now, what about the petition of right? Was that significant? Is that still embodied in British law or the British Constitution?
Well, the biggest turning point in the further evolution of the British Constitution came in the 17th century, when we did have a king, King Charles I, who sought to become an absolute monarch again, an autocratic ruler, and to rule without Parliament. And he repeatedly prorogued Parliament, which means suspending it. But from time to time, he needed money, and only Parliament can authorize taxes, although Charles I even tried to get around that. And that led to the Petition of Right and other abuses by King Charles by trying to govern without Parliament, eventually led to a revolution, what we know as the English Civil War, which took place in the 1640s. And after several years of a very bitter civil war, in which a lot of people got killed, for us, it would have been the equivalent of the American Civil War that took place in the 19th century because of the slaughter. Parliament, led by Cromwell, the Parliamentary Army, eventually prevailed. King Charles was defeated, captured. Initially, he was imprisoned while Parliament debated what to do with him. And that was a big dilemma. And Parliament eventually decided, many of them very reluctantly, that they should execute him. And King Charles was executed in 1649. And for 10 years in the 1650s, Britain, England, I should say more correctly, was a republic. We had no king until the death of Cromwell in the late 1650s. And Parliament then decided to return to being a monarchy. And they invited the son of Charles I, who was living in exile in France, to return to England to become King Charles II. And that period is known as the Restoration. But Charles II had to govern subject to Parliament, who had invited him back. We then had one further wobble in the late 17th century, when the son of Charles II, James II, also tried to rule without Parliament, and he was a closet Catholic, And at the time, England was fiercely Protestant. And so he, in effect, was chased from the throne towards the end of the 17th century in 1688. And a new monarch, well, two joint monarchs were invited to assume the throne, known to us as William and Mary. This was Prince William of Orange from the Netherlands, another very Protestant country, and his wife Mary, who was herself by birth a Stuart. So she had been part of the English ruling dynasty. And William and Mary were invited by Parliament to assume the throne, but very clearly subject to the consent of Parliament and on condition, in effect, that they recognized parliamentary sovereignty. And that was declared in an act passed by Parliament in the first year of their reign, called the Bill of Rights Act. It's misleadingly titled. It wasn't really a Bill of Rights. It was a bill about parliamentary government and about how from now on we were going to be a constitutional monarchy with the monarch reigning and ruling subject to Parliament. And that's what we've been ever since.
So the English Bill of Rights then is not comparable to the American Bill of Rights?
No, in no way. What is comparable to the American Bill of Rights is our Human Rights Act, which was passed much, much more recently, just 25 years ago in 1998, and that incorporated into British domestic law the European Convention on Human Rights. We've been subject to the European Convention on Human Rights ever since the Second World War. We were one of the very first countries to sign and ratify the European Convention in 1950. And that was adopted by most of the countries of Western Europe, in effect, to try to ensure that never again in Europe would we see the terrible abuses of human rights that had taken place in Nazi Germany and had been inflicted by the Nazis on all the other countries which they conquered during the course of the Second World War, and which, as we all know, led to the slaughter of 5 or 6 million Jews in the concentration camps.
What role did men like Edward Coke and Algernon Sidney, John Locke, Blackstone, what role did they have in shaping English law and the English Constitution or the British Constitution?
They had an important role. The list of names you've just read out is mainly leading lawyers and judges. So to take one example, Edward Coke was a famous Chief Justice in the early 17th century. And he stood up for the rule of law, the independence of the judiciary, and the common law is one of Britain's and England's great gifts to the rest of the world, including America. And the common law actually goes back very much further, because the king's justices first were sent on assize to all the different parts of England back in the Middle Ages. And it was their judgments delivered in the king's courts, which were recorded at the time by scribes, that became the common law. And that has always been the common law tradition, that it's developed through case law by the courts deciding on individual cases. And it's the accumulation of all those individual judgments that form the basis of the common law.
So after we had the American Revolution and then the adoption of the Constitution in America, what influence do you see of the British Constitution on the American Constitution?
Well, one is what we've just discussed, in effect, the adoption of the common law as the basis of the American legal system. The other influences, and forgive me, I'm not super expert on this, I think you have to trace through the debates of the founding fathers in the Philadelphia Convention. And my understanding is that one of the really big issues that they grappled with right until the last weeks of the convention was how to select the head of government, and in particular the head of state. They knew they didn't want a king. And so how, if you're not going to have a king, do you choose who's going to be the head of state? And interestingly, my recollection is that until the very last weeks in Philadelphia, they were heading towards a parliamentary system of government, where the head of the government would be chosen from the legislature, from Congress. And it was only right at the last moment that they decided that instead the head of the government should be separately and directly elected. And forgive me, I can't now remember the reasons why for that last minute very big change. It was a very big change. As I said earlier, it led America to choose a presidential system of government instead of a parliamentary system. And most political scientists would say that a parliamentary system would have been preferable.
Now, around that same time as the American Constitution, of course, was the French Revolution, and had the French Republic for a short period of time. Was there any influence between British law and tradition on the French revolutionaries, or some of them? I mean, there were many factions.
Well, there were some from British intellectuals, notably a man called Tom Paine, who's also well known in America because he had an influence on the American Constitution. And he was a famous supporter of what we would now call in Britain human rights, in America civil rights, because he wrote a very famous book in the 18th century called The Rights of Man. So I think our influence on what happened in France was mainly an intellectual influence through the writings of Tom Paine about the rights of man, and through the writings of a philosopher called John Locke about the separation of powers. And that in turn influenced a French intellectual called Montesquieu, who wrote a famous book called L'Esprit des Lois, in which he also advocated the separation of powers and referred to the English model.
Did Montesquieu? I've read that he misunderstood the British Constitution and lavishing all the praise on it. Is that accurate?
I've read that too, but forgive me, I can't now remember any of the
Okay,
details.
that's okay. In America, we view our Constitution as a restraint on government power. It's meant to protect the liberties of the people. Is the British Constitution viewed in the same way as a protection of the people?
Yes, all constitutions do two things. They define the powers of the main organs and branches of government, and they then impose limits, checks and balances on what each branch of government can do. And the main limits are imposed by the different branches of government on each other. So in the British system, the main check on what the executive branch can do is Parliament, because the government can only continue to exist so long as it retains the confidence of Parliament. The moment it loses that confidence, the government must resign or call fresh elections. That's a fundamental principle, convention in our Constitution. And that's a very, very severely limiting factor. The parallel in the United States is the difficulty that many presidents have in either passing laws or getting money approved by Congress. A current example would be the bill, which I understand is stuck in Congress, that would approve billions of further financial aid to the Ukraine. So that is a very fundamental check and balance on the British government. Another is the courts, in that every bit of government and every public body is subject to what we call judicial review, and therefore they cannot stray beyond their legal powers and legal authority. And that's a very real check. Public bodies are very frequently challenged in the courts by means of judicial review. And if they haven't followed due process, or if they have exceeded their powers, then the courts will strike down what they have done.
See, it seems to me that regardless of whether there's a constitution or not, when people are voting, that people ultimately get the government that they want. And by people, I just mean the majority of the voting population. So even if you have a constitution in place, if the people wish to go beyond the powers granted in the constitution, the politicians are just going to respond to that, give the people what they want. And in America, our government has grown far beyond what was ever intended by our Constitution. First of all, do you think that constitutions actually serve that function? Do they keep the government? I know that they act somewhat as a restraint for the reasons that you just gave, but do they keep the government in check in ways that were intended by the people that formed these constitutions? In Britain, I know it's different because the Constitution's subject to change based on the people that are, elected and appointed.
You're right. Constitutions, in theory, are meant to operate as a check and balance on the government. In practice, and we've seen recent examples of this in the United States and in Britain and in other advanced democracies around the world, rogue actors in government can override or abuse the Constitution. I would cite as examples in the US, Donald Trump, in the UK, Boris Johnson. And it's really difficult if you have a rogue actor leading the government for the Constitution to rein them in. And, there are many constitutions around the world which look very good on paper, but in practice cannot control a rogue actor.
Yeah, I once belonged to a group, and I thought that the other members of the group weren't behaving appropriately. So I said, I got a great idea. We'll come up with a code of ethics for us. And we drew up, and everybody agreed to the code of ethics, and nobody adhered to it. And there was nothing that could be done about it. They just explained it away. Well, we don't want to be rigid. You got to allow for exceptions. And that's when I really learned the lesson that you just said, that these things are just words on paper if people aren't willing to adhere to them. But what, in your view, does a better job? Does an uncodified constitution like the one in Britain do a better job of restraining government, or does a written constitution like we have, or are they just basically?
That's not an easy question to answer, because in the case of a written codified constitution, it depends on how easy it is to amend and update that constitution. And the American Constitution is notoriously difficult to amend. Your American listeners will know the requirements. I can't remember them for certain, but it's a high threshold, requiring, from memory, the agreement of, is it 3/4 or 2/3 of the states?
It's 3/4, I believe. I think it's 2/3 of the legislature, 3/4 of the states.
Then that's a high threshold, and it means the Constitution is very difficult to amend. which means that the constitution is very difficult to keep up to date. And all constitutions need to be updated to keep up with the times. So in that respect, it is easier if you have an unwritten or uncodified constitution. So here in the UK, we've made very big constitutional changes just in recent times, simply by passing acts of parliament, by passing new laws, which now form part of our constitution. To give you some examples, when Tony Blair first became Prime Minister in 1997, in short order, he was able to introduce very big changes to the constitution. So for the first time, we introduced a new level of government in Scotland and in Wales. We became a kind of quasi-federation, whereas before we'd had a very centralized system of government, with all parts of the UK being ruled from London. Scotland now has its own parliament in Edinburgh. Wales has its own parliament in Cardiff. And Northern Ireland has its own parliament in Belfast. That was a very big change, which was done by passing in 1998 3 separate laws to create those parliaments in those parts of the UK. In the same year, we passed the Human Rights Act, which I've referred to earlier, which in effect gave the UK an enforceable Bill of Rights. And in the same year, a year later, 1999, we passed the House of Lords Act, which removed almost all the hereditary peers from the House of Lords, which is the second chamber of our Parliament. A much overdue reform, again, simply carried out by an Act of Parliament. So the beauty of an unwritten constitution is it's easier to amend, but that also, you can see, might be regarded as a risk, because there's a reason why constitutions are made difficult to amend, so that people can't easily change the rules of the political game. And it's a difficult balance to strike. Some constitutions are seriously difficult to amend, the American being one, the Australian being another. To take a smaller country, Jamaica, theirs is also terribly difficult to amend. That, in my view, is a handicap. You need to strike a balance, but there's nothing wrong in having a written constitution. It needn't be inflexible, so long as it can be updated and amended without too much difficulty.
See, to my mind, the Articles of Confederation were difficult to amend. They just got rid of them and replaced them with something else. So the British Constitution, as you said, it evolves, it changes over time. Where do you see it headed over the next, I don't know, 10, 20 years? As far as for the civil liberties in British public policy, and Britain's relation with the rest of the world?
I don't see any major changes likely to come up over the next 10 years or so. It's very likely when we have our next general election, which will be later this year, that a Labour government will be elected. But they don't have any very big plans for constitutional reform. The most that they might do on the constitutional front is to strengthen some of the constitutional watchdogs to try and prevent the abuses that we saw under Boris Johnson. But that's pretty minor stuff constitutionally compared with the very big constitutional changes that happened under Tony Blair. The big unresolved issue for the UK is our relationship with Europe following our departure from the European Union, following the Brexit referendum of 2016. And I don't see that being resolved in the next 10 years. I think under a Labour government led by Keir Starmer, we will try to get a bit closer to our former partners in the European Union, but it will be a rather crabwise, softly approach, because neither of our major political parties is yet willing publicly to admit that Brexit was a very serious mistake. All the evidence is there in terms of the damage that Brexit has caused, and we see further evidence of that week by week and day by day in the impact on trade with Europe, in the impact on the British economy. But because the people voted in a referendum for Brexit, it's really difficult for leading politicians in both major parties to admit and say to people, we made a mistake, you made a mistake in voting for it.
Yeah, I know in America, politicians are very fond of saying the American people don't want this, or the American people that there's no criticism ever. The American people are sacrosanct, can't ever get anything wrong. And I'd imagine it's a similar dynamic in Britain that nobody wants to tell the people, listen, you really fouled this one up. We need to, change course. So, is there anything that we didn't discuss about the Constitution in this brief discussion that you think we should have covered?
No, I think we've covered all the ground really well. You're a very good interviewer.
Thank you very much.
And please forgive me for keeping you waiting at the beginning.
Oh no, that's fine. Okay, Professor, where can people find you? Do you have a website or a blog or anything?
We have a blog. It's called the Constitution Unit blog. I set up a think tank now almost 30 years ago at University College London called the Constitution Unit. So anyone can find me by Googling the Constitution Unit UCL.
Excellent. Thank you very much for joining us and sharing your knowledge with us, Professor. For now, this is the Rational Egoist signing out. I'm Michael Liebowitz. Till next time.